Okay, guys, so let's pick up where we left off. You're a member of a state bar. This is California, New York. It neither permits nor requires disclosure of information in circumstances described or addressed in Model Rule 1.6b2 and 3. You work in-house in the tax department of a publicly traded corporation. You recently learned the company has not been paying state use taxes in several states on purchases which vendors have not charged the appropriate sales tax. That this situation has been ongoing for several years. You believe that the amount of tax owed, coupled with the applicable penalties and interest, could be substantial, and are concerned that should word get out, adversely affect the publicity and the stock price. You believe the VP for taxes probably will not look favorably on your recommendation that the company voluntarily disclose the situation to the relevant state tax authorities. And there's a regulation, this is in the context of the SEC, that an attorney appearing before and practicing before the commission in representation of an issuer may reveal, emphasis on the word may, without the issuer's consent, confidential information relating to the representation to the extent the attorney reasonably believes necessary. And it talks about different situations, including a material violation that might cause substantial injury to the financial interest or property of others. Can you reveal this information to the SEC? If you can, what considerations would you weigh in deciding whether not to or whether to do so? All right, guys, this is you. And Ping, you get the honors because you can, Ping, if you don't know, Ping has said on after several classes that I may have, you ever hear the movie Scared Straight where they try to scare people not to take drugs? So the equivalent is if you come to this class, you may decide not to practice tax. But Ping is now you're in-house, right, Ping? And so she feels she's a little safer than everyone else here who practices maybe with clients. But Ping, you're not that safe because this could happen to you, right? So what do you do, Ping, in this situation? And Viva, see if you agree with her.
I will resolve internally, not explode to, authority first.
What do you mean by resolve?
Because he is like, working in the company and then get information from review the other people's, work product or information from the other side. So.
Well, there's no other side, right? I don't know what you mean by the other side.
The other side, which is like authority, like ours will always resolve internally, and then we will, if it's
Notice
severe.
Ping is trying to take the juice out of this problem by saying she uses the word always resolve, as if things are always comes
No,
out.
it's not. If it's not resolved internal, you can do whistleblower.
With who?
You can disclose.
No. Yeah, whistleblower. You only use the whistleblower rule to, disclose.
So what would you do, Ping? I mean, the easy answer is, oh, we would resolve it, but suppose the VP says no.
Then you put in your resignation first.
Yeah.
You submit your resignation, then what do you do?
Blow the whistle.
I mean, but V, that said, I mean, from, how do you say, the safety of having potentially a spouse who, but if you're a single mother or single father and this is your livelihood, right? Let's be real. Mm-hmm. Are you going to, what are you going to do in this situation, guys?
See, if you ask the VP that to disclose the information, he said no, then you, if you want to withdraw and you.
What do you mean by the word withdraw in this context?
No,
you mean hide in a corner?
No. You can.
I mean, this is not like you can fire the client. Your client is your employer.
I mean, wouldn't you?
And by the way, is it going to be easy to get a new job if you say, I'm very uncomfortable here.
No, but I think you still take the same approach, maybe that you are an attorney, according to what it says, you're not required to, right? Because it
Right.
says either in California, New York, so why can't you just do the same thing, you know, address whomever it is, have a disclosure saying that this is what you recommend be done, and it's not done, and then you resign, and then.
But
if
be
you
careful,
ever
what
get-
does the word resign mean here?
Find another job, adios.
So you find another
At least you
job,
cover yourself,
then
you
you
said I'm more
resign, and then you go to
marketable
the school.
somewhere else. And
I didn't catch
I-
B, what did B say?
Find another job first, then you put your resignation, and then you blow the whistle.
But why would they give you a bad reference when you were shutting up? So in essence, that's what I would do. I would say, hey, listen, it's my recommendation, cover your ass. And why would they say, no, don't hire this guy?
But, you know, finding a new job's not so easy, particularly geographically. If you have young kids in a school system, I mean, I could paint an
Demand
idyllic
severance.
picture like, oh, you find another, you move across country,
And you
isn't
tell
it?
them, I demand 6 months severance or I'm turning you in.
Well, let me run into the extortion
There you
issue
go.
though.
That's how you
Well,
fix it.
really, I think what you're looking for is that the person should document it, that the person escalated it to these levels, and given the position of authority of these people over him, he or she cannot really do more than that, right?
I mean, many companies do, and this is getting on very shaky territory, have procedures in place that if you think it's a problem, that you can bypass the chain of command in unusual there's supposedly, now, whether or not those really work, many people will tell you, yeah, you go outside the bounds, you will be fired, you will, you know, can you imagine the VP who thinks he or she is correct and you go up the chain over her or over him? What's gonna happen going forward? Not gonna be a comfortable situation. So Ping, if this is you, you're in a tight situation. I
I
mean,
will document.
the only thing you
Bring
can
the
document
issue,
is that you.
and then, since we have like a company, big company, they do have a compliance. They have hotline, compliant hotline. So you have to say, okay, pick up a phone, hotline, and then to disclose the issues.
Right, I
If it's
mean,
not
you
resolved,
should,
you
if
have
the
to
company has a
document on
procedure
your
in
side.
place,
Mhm.
you know, you will try anonymously and you'll try techniques to perhaps make disclosure and document it. But if you wanna get real, Peter, you know, I don't know if you're gonna submit your resignation, just because people work 10, 20, 30 years, they wanna get the pension. There's their kids are in middle school, their elderly parents, I can give you 100 different reasons that they may not want to or cannot move.
Does it depend if they're unionized too?
I mean, you know, that could be another factor.
Because unions usually, benefit their members.
I mean, there's a reality that the union is out there in the ether, and then you have to come to work every day and deal with the dynamics of your VP.
Right.
So, you know, notwithstanding the protections of the union, you know, there's the interpersonal things, and if you just made your number one enemy is your boss immediately above you, I can promise you life is not gonna be pleasant.
So then you shouldn't, right? You shouldn't reveal it then?
I mean, here we are, guys, we're in an ethics course. Here we are talking about the stickiness of this and saying try to protect yourself by going through proper channels. And to the extent, you know, look, you're trying to do the ethical right thing, but simultaneously we all have ourselves that we're trying to protect too. We're trying to protect the institution, we're trying to protect ourselves. And they may not exactly fit nicely together. And, you know, so it's not like I can give you the perfect solution here, nor can anyone. But there may be, as Ping is suggesting, maybe there is someone internally that functions as the company liaison or ombudsman if there's an issue. And what is their procedure? And sometimes companies have very good procedures and maybe you can tap into. Some are very poor, and what can I tell you? It's you'll try the lesser of two evils. So,
convince your coworker to do the reporting and put it all on them.
Just let you know, because I'm working at the internal audit. So some case project we work on is through those hotline, the compliant issues. So we do pick up some.
you do pick up some issues from compliance hotline. Is it done
Definitely.
anonymously or not?
It is both, either way.
Sometimes you
Sometimes
get-
it's management, even though the VP maybe not say, we will take care, they probably will report to, other department, like internal or other, they probably will say something if it's so severe.
Okay,
So, which is,
all right, look, the message, the takeaway from tonight is that, when these kind of situations come up, there's something to be said, you're not alone, okay? When I say you're not alone, you are alone, but these kind of things, there's textbook questions to remind you that these things happen in all spheres of existence, and you're not alone because other people, there's something to be said knowing that other people have to endure these difficult ethical issues. To just remind yourselves of that. All right. And then problem 4-9 deals with the issue of prior and prospective clients. It just says you have an initial meeting with PNC, as in possible new client. PNC is under audit by IRS with respect to 2014 return. PNC tells you some questions that have been raised about business travel expenses and other matters. PNC seems nervous. You ask whether PNC has any specific concerns beyond the question issues. PNC says, I did not answer the question about foreign bank accounts accurately because I had $45,000 in interest from foreign accounts I didn't want to pay any tax on. I haven't ever reported interest from my foreign accounts. Okay, so PNC has a right to be nervous, right, guys? You and PNC agree that you are not the lawyer PNC needs, right? PNC may need a real criminal attorney. You suggest that PNC contact a criminal attorney, and you provide him with the names of several skilled attorneys. Can you disclose anything about this conversation to the IRS or your tennis partner?
no.
And the answer is no. Everyone agree? The model rules, and that's clear too, because again, from a policy reason, the American Institute of CPAs and the American Bar Association wants people to be forthcoming, and if people, even prospective clients who are not your clients, there's an expectation of privacy, because if they make these disclosures, or they wouldn't make these disclosures if they thought there's any chance that you would go to the tax authorities or talk to your tennis partner, right? Their reputation would be on the line. All right.
You cannot tell anybody, but you can give the example of that client, right?
You cannot tell anyone, or you can lecture in front of a class like this and speak in the terms of anonymously, right? Because for better or worse, a lot of people fit the prototype of this situation. All right, you brought your code. I was thinking to myself before class today, always trying to, it's good memory exercise. There's 3 code sections that don't come up too often, but come up in this class that you should just think about. The first is code section, let's see if I got my memory right, 7491. Okay, I try to do it in order. So let's see if I get this right. This is burden of proof that 7491. That most of you know that the initial burden of proof does fall on the taxpayer when it comes, right, this is civil litigation. Civil litigation, who is the burden of proof on? This is not a criminal matter, so you are not guilty before, unless proven innocent. Code section 7491 just affirms that the initial burden of proof is for taxpayers to come forth with information, right? It's not a question of innocence or guilt. And does this make sense from a policy perspective? And the answer is yes. Why? Because who has access to information? The IRS or taxpayers? Hmm?
Yeah, I don't know.
Taxpayers.
I mean, initially taxpayers.
Oh, I thought you meant like resources.
No, but taxpayers have the easiest access, right? So the notion is, in the initial, once they come forward with credible evidence, then the IRS has to come back and say why its position is correct. So the burden of proof can change, right? So I'm just pointing out, these are three code sections. The second code section we looked at last class, code section 7623. What is code section? Because this will come up, people will say, oh,
Which one?
70, I forgot the one in between, which we're gonna look at right now.
We
But
don't have-
look at 7623. Oh, is it in our code book even?
No.
Okay, 7623 is the whistleblower awards. 7623 is the whistleblower. And sandwiched in between is 7525. So if you want to open up to 7525, it'd be a good idea. It says, with respect to any tax advice, the same common law protections of confidentiality, which apply to a communication between a taxpayer and an attorney, should also apply to communication between a taxpayer and any federally authorized tax practitioner, that means a CPA, to the extent the communication would be considered privileged communication if it were between a taxpayer and an attorney. So this is what Bob Stern was talking about and I was alluding to about the accountant-client scope of confidentiality, right? Now, Congress, the AICPA fought hard at this in the Internal Revenue Code, offering to some degree the protections that clients have with their lawyers to extend to accountants. But, as Bob Stern warned, and I think I alluded to, it only applies to non-criminal matters. So if your client is talking to you about a criminal matter, as an accountant, there is no confidentiality. So that's not good, right? And if you look at Code Section 7625B, it specifically says section not to apply to communications regarding tax shelters.
So again, this applies only to criminal acts not committed. Once it's committed, right?
I don't, to me, there's no timing before or after. So if there's any conversation, to me, pertaining to criminal matters, whether committed or not committed, I don't think you have a protection.
But then
for a
let's say
CPA.
someone murders, a guy murders his wife and his attorney knows that this murder has been committed.
Right?
Oh.
Should the attorney then not represent him?
You should,
Okay,
but if the accountant learns, the guy, I come to you, you're my accountant, and I say, listen, I can't file jointly anymore, I murdered my wife. Okay? You can disclose that and you're not gonna be violating the privilege here.
What if you also happen to be an attorney?
That could be a problem.
Oh, yeah.
I mean, but if you're defending this person and you know that this person murdered his wife.
Well, but that's, what my point is, an accountant does not have the
Oh.
protection of the confidentiality.
Okay, that's why those call them.
We're gonna talk about
Okay,
that,
okay, yeah.
okay? So, the point and it's an important one that Bob Stern made, and I'll emphasize it, is the attorney-client privilege is very, very broad, okay? Attorney-client privilege, essentially as V was suggesting, if I go to my attorney and say, I can't file jointly, I murdered my wife, he or she can't disclose that to anyone, okay? Cannot disclose that to anyone. But if I do, come to my accountant, who's not an attorney, and say I can't, for the same reason, the disclosure, the rules don't apply. And if I'm investing in a tax shelter, and I tell my accountant, look, I am doing some pretty shady things with this tax shelter, and the attorney subpoenas the accountant's records, the IRS can get access to those records. The accountant, that pertains to a tax shelter, the accountant can invoke 7525. And that's the key, by the way. Here are the verb. The verb is subpoena. The IRS has the right to subpoena. Subpoena means gain access to documents. And the defense to a subpoena can be a privilege, and the privilege that we're going to learn about are essentially two: confidentiality or the work product doctrine. So everyone understand the IRS may want access to information, and it's within its rights to subpoena and ask for information, but your legal counsel can try to shield access under, again, for purposes of this class, two theories. And tonight we're really focusing on the first of the two theories. Saturday we're going to be looking at the second of the two theories. Now, look on page 167, the second full paragraph. Now, on 167, sort of summarizes the Frederick case, which is to follow. But let's just get, I think, two of the salient points that flow from Frederick out of the way. This is in the second paragraph on page 167, 5 lines down. First, communications made by a client to assist her advisor in preparing a tax return are not privileged, primarily because the client cannot be said to have an expectation of confidentiality with the subject the communication will be disclosed on her tax return. All right? So, information pertaining to your tax return is not privileged. So everyone got that? It's not legal advice. It's preparation of a tax return, not considered legal advice. Disclosure can be made. Second, the case cast doubt on the wisdom from the perspective of privilege of an attorney or federally authorized tax practitioner preparing returns or representing clients at audit where other services such as tax planning are provided to the same client on the same matter. Because it's hard once you're doing tax return preparation and you're doing tax planning, hard to draw the line when a subpoena is issued where you say, oh, that tax planning wasn't related to the tax return, and trying to draw a line of what's protected or what's not. So what it's suggesting is that clients would be wise to hire like H&R Block to do their tax returns, but hire someone with your breadth of knowledge to do tax planning, because that tax planning is really legally oriented and there would be protections. But once you do both activities, the IRS may have a much easier time to gain access to information. So, beginning on page 168 is this Frederick case. Frederick is both a lawyer and an accountant. And Frederick had some of his clients' records where attempted to be subpoenaed. And Frederick's counsel said the attorney-client privilege applied, or the work product privilege. So 2 different privileges that Frederick is going to invoke. And at the lower court level, remember, this is at the 7th Circuit, and at the lower court, some of the documents were ruled privileged and some were not. And the opinion says that some of the documents, this is the 3rd full paragraph, were created in connection with Frederick's preparation of the tax return. And we're seeing if there's still, are we still being videotaped or?
Yes, as of now, but it's looking iffy.
Okay. Is that because you're running out of battery or?